everybody, welcome back to Immigration Dream University. My name is Tadisha Rowe. I'm an attorney in the DMV area located in the United States. I do practice immigration law nationally, and if you are international and would like to immigrate to the United States, I can probably help you with that as well. So today we're going to talk about what to do if you file to adjust your status within less than 2 years of being married. You can absolutely do that. The government is going to issue you what is called a conditional green card. And all that means is that they are trying to make sure that you are not trying to circumvent the government, which means that you're trying to evade them or commit some type of marital fraud, which we spoke about in the first video for the month of February. They're just trying to cover their bases and make sure that 2 years later, you two are still going strong in terms of the marriage. That is all well and good. However, we do know just from real life experience that sometimes that is not exactly the case. More and more what I'm seeing, and many immigration lawyers are probably seeing, is that there are issues that arise in marriages just like in any other marriage. However, when you are an immigrant, it puts you in a particularly vulnerable situation. And so many times there might be some kind of abuse or harassment based on the fact that you are an immigrant and based on the fact that you are relying on your significant other, your spouse in this situation, to help you to get a very important benefit, which is to adjust your status in the United States. In most cases, everything goes well. Spouses typically tend to be very supportive of each other, but then in other circumstances, that may not necessarily be the case. So what do you do if it's time now to file to have those conditions removed from your green card and you and your spouse are no longer together, or maybe you have in fact divorced? Well, the government actually does have you covered for that. Under normal circumstances, you and your spouse would have to file a joint petition. It's Form I-751 to remove the conditions. And essentially, you're just picking up where you left off from when you first filed to adjust your status. And so you're going to continue with that history that you built up until that interview point and when your green card was issued and you were so happy and relieved that they granted the approval based on your interview and based on the documents that you submitted. So now it's essentially time to go through that whole process again. You want to start from where you left off and you want to continue to build the history. So from the time of the interview until now, until 2 years later, we have done this. Maybe you've purchased a home together. Maybe you're leasing a place together. You have your joint bank account. You continue to share funds or use the same account. You're on each other's insurance policies, each other's gym membership. You go to church together, you go to different community activities together, different family functions together, and you take pictures and you document all of that. Maybe you guys have a child together. All of these things are relevant when you're trying to get the conditions removed from your green card. However, like I said, there are unfortunate circumstances where maybe this is not the case. Maybe during this time, you have been a victim of some kind of abuse, or for whatever reason, you and your spouse no longer have a meeting of the minds in regards to the marriage. And it's not that it wasn't a good faith marriage in the beginning, but for whatever reason, you two are just not getting along or have decided to go your separate ways. If that's the case, you can actually file a waiver to the joint filing of that I-751 petition. What that essentially lets the government know is that again, you're not trying to circumvent the government, but your good faith marriage is no longer viable or soon to be no longer viable. The government will grant the waiver based on the type of evidence that you submit to them. If you have already filed for a divorce, then they will more than likely ask that you submit the final divorce decree. If you are separated from your spouse and you two do not file jointly, you will need to file that waiver at that time, explaining why you are not filing jointly. And the anticipation is that you will at some point be filing for a divorce. So that is what you would do in those circumstances. Now let's say that you are with your spouse and you two originally thought that you would adjust your status based on your marriage. But then for whatever reason, your spouse decides that they are no longer going to file that petition allowing you to adjust your status. They don't have to do that. So that's the first thing. They are not obligated to file that petition on your behalf. It's actually a very significant commitment that they make when they file that petition, because they're also saying to the government that they plan to support you until certain requirements are met and you're able to support yourself. So it is a big obligation that they're undertaking, and not something that should be taken lightly. However, in some cases, people again use that as a way to manipulate or abuse the other spouse. And if that's the case, and you are in a good faith marriage, however, your spouse decides that they're going to manipulate you, they're going to emotionally or physically abuse you, then you do have other alternatives, and that is what we will be talking about in the next video. So guys, I hope that this information was helpful for you today. Once again, please do like, subscribe, comment. I would love to hear your feedback. And if you do have personal immigration questions, please call me. This is legal information, not advice. To get legal advice, call me, set up a consultation. We can be reached toll free internationally, and we look forward to hearing from you. Bye, guys.